Are you ready, sir? Okay, we're here now for Pratt versus Smith and Mr. Specht. John Specht, you may begin.
May it please the court, counsel, good morning. I just wanted to start by saying it's a real honor to be here before the Iowa Supreme Court, so thank you for hearing me today. We've already pretty thoroughly discussed the issues in at least the main appeal that we're here for today regarding the negligent retention issue, but I wanted to bring up a couple things. Number one, what Mr. Wright and defendants here are trying to read into the statute with regards to the negligent retention claim, it's just not there. So what we have here is a personal injury matter for injuries for a patient arising out of medical care. That's essentially the case within a case. Now, we don't dispute that a certificate of merit is needed for that underlying case within a case. But what's separate is an employment claim on top of that. And if you look at the wording of 147140, it requires that for the COM, there's an expert witness meeting 147139. Well, for the employment decision, I don't see how a person could meet 147139 and be in compliance with this. So is the question here the hiring, or is it the underlying care? And here, the underlying care requires the certificate of merit, but we have that here. And so when 147140 says a cause of action, that's the broad overall case, which includes these negligent retention claims, but includes the underlying case. So it's like a Russian nesting doll. To get to the outer level of the doll, you have to have a certificate of merit. So this is it's a personal injury case arising out of care for which you need an expert. We don't dispute that. So we have that outer layer of the doll, which is the expert. But then once you've passed that threshold, there's this separate case, which is an employment case. That's not a medical case. And it's a bit of a separate issue, which I'm sure we'll touch on, but we would submit you do not need an expert for this employment case. And so really, what 147140 is doing is it's getting rid of frivolous cases. And by us having an expert for the underlying case, we've met that threshold. We've gotten past the level of, is this a meritorious case or not? So then the question is, under Godar, completely separate elements, negligent retention under the Iowa jury instructions, that's not a medical question. It's a completely different section of our civil law.
Discussions that we've already had, Godar is ultimately requiring a finding that the employer knew or should have known its employee's unfitness, right? And my concern is that deciding whether or not a doctor is unfit or fit, whether this clinic should fire this doctor because they can't practice medicine anywhere. That feels like a decision that is beyond the knowledge of me, certainly, and I suspect a lot of lay people as to how to evaluate a doctor. Whereas here you don't have, nobody's yanked his medical license and that sort of thing.
Thank you, Your Honor. And it could be the case that, I believe this was touched on earlier, but this could be a situation where you do require an expert for a jury question on that. But that's separate from the issue of, are they required to dismiss the claim under 147140? Because 147140 is based on the dismissal for failure to have a certificate of merit. That's a separate issue of whether you ultimately reach a jury.
You have situations where a case requires more than one certificate of merit, possibly on different issues, right?
That's an ambiguity in the statute. It's clear from the statute that you require certificates of merit for separate defendants. That's clear in the statute. The statute doesn't say you need a separate certificate of merit for each cause of action. That's explicitly not stated, especially if it would be against the same provider. I can give you an example. Say that someone got a surgery that was alleged to be negligent on day 1. On day 30, the same person gets the same surgery from the same defendant doctor. There's 2 separate negligence counts in the petition. Would you need 2 separate certificates of merit against the same doctor?
But this is 2 different defendants, right? 2 very different defendants in terms of the doctor versus the clinic, right? And they're both, under the statute, healthcare providers. They're both entitled to protection under the statute, right?
Thank you.
Issue relating to Dr. How do you pronounce it? Marufuji?
Again, what we believe the defendants in this case have done is they're reading something into the statute that's not there. If you look at subparagraph 1 of 147140, it says the person is licensed to practice in the same or a substantially similar field as the defendant, is in good standing in each state of licensure, and in the 5 years preceding the act or omission alleged to be negligent has not had a license in any state revoked or suspended. The words actively are not in subparagraph 1. However, the word actively is in subparagraph 2. In the 5 years preceding the act or omission alleged to be negligent, the person actively practiced in the same or substantially similar field.
Just said the person is licensed without saying to practice. Is that different than saying licensed to practice?
I don't believe so, Your Honor. And also in looking at the sentence, it doesn't end at to practice. It says to practice in the same or substantially similar field. So you have to look at not only the entire statute, but also the entire sentence. To practice isn't dangling there. It's saying to practice in the same or substantially similar field.
Licensed to practice and able to practice today.
Well, I think that's reading something into there that's not there, especially since the word active is used in another part of the statute.
Saying, but you have to be able to actively practice. Why doesn't to practice mean that? Like if with the doctor at issue here, if he so he retired, so he's got an inactive license, so today he could not go practice because his license is inactive. He could go and get it reinstated, and then he would be licensed to practice. I guess so. Why is he still licensed to practice when his license is inactive?
I would argue that the to practice is not modifying the license, it's modifying the field. The phrase to practice is referring to the second half of that sentence.
Am I overthinking it? License to practice means you have to be able to practice. And at the time he wasn't.
Well, license is different than actively licensed. That's our contention here.
Well, it's different from actively practicing. As Justice Oxley points out, that would mean he has to actually be practicing, whereas licensed to practice just means he has to have the authority to practice should he choose to do so. But he didn't even have that, right?
Well, under the laws of New York and New Jersey, where Dr. Marufuji is licensed, there's such a thing as an inactive or retired license. So he was licensed. He was just on inactive status.
Guy is licensed. But doesn't it seem like you're trying to have us look the other way on the 2 words to practice?
Well, I think that in the canons of statutory construction, you have to look at the whole picture, including both subparagraph 2 mentioning the word actively specifically, and
So you either have to have been practicing for the last 5 years actively or being a qualified instructor at an accredited university. Do you know whether professors at medical universities are generally licensed with an active practice license?
I don't know what the general practice is in the medical profession. I can tell you that I've seen both.
If there's an instructor who has for the last 5 years taught and is still teaching, but doesn't have a license to actively practice today, they would not be qualified under the reading, if we're reading license to practice the way the district court did.
Under Mr. Wright's briefing, that would be correct.
Subsection 1 of 147.139, is that license to practice in the same or substantially similar field, is that as of the date of signing the certification, or is it another date?
Yes, Your Honor. With regards to subparagraph 1, that refers to the date of the signing of the certificate of merit, and subparagraph 2 contemplates the 5 years before the actual act underlying the entire claim. So there's 2 separate time periods contemplated here.
Subsection 4, and does it work differently than subsection 1? That's one that says that if the defendant is a licensed physician under Chapter 148, the person is a physician, the person meaning the expert, is a physician licensed in this state or another state. Is that different than subsection 1?
I think it's addressing the situations where you might have a nurse practitioner or PA who prior to the 2017 law might have been testifying, because prior to that, the expert standards were based on experience or the particular procedure, whereas now this law clarifies about parity between the expert and the defendant at hand. So like now you could not have a nurse practitioner testifying about a physician.
Kind of working through this subsection 4. It doesn't say license to practice in subsection 4, it just says license. So here we're dealing with a licensed physician on inactive status. Could that omission of license to practice as a physician from 4 argument that to practice in subsection 1 actually modifies in the same or substantially similar field?
Our contention, Your Honor.
Let me ask you, unrelated to the substance issue. So we've got 2 different appeals in this case, and the second order was entered quite a bit after the interlocutory review was granted. I'm concerned about whether the district court had jurisdiction to act in that situation.
I don't know how to address that question, Your Honor, because it is an unusual situation.
Opposing counsel has an Ohio case, and there are certificates of merit in a lot of states. Do you have any persuasive authority from other jurisdictions that have addressed the inactive license issue under a similar statute?
Hand, Your Honor, I think this is a fairly novel issue that's come before the court today.
If this statute requires the person to have a current active license to practice to be an expert, is that a significant change to the types of experts that would be allowed in med-mal cases in Iowa?
I believe it certainly would, because, you know, when you have doctors who are actively practicing, a lot of them are wanting to focus on medicine. They're not wanting to focus on testifying in cases. On the other hand,
Legislature's intent. I mean, that's the thing. It could be that the legislature really wanted to make sure that people who were going to appear as experts and testify that somebody had committed malpractice continue to have sort of skin in the game, that they were still licensed to practice medicine, and that they weren't retired, that they were talking about a profession that they were still engaged in.
that could be a possibility. I don't think that we can reach that conclusion based on what's in front of us in the law and on the principles of statutory construction.
I just still think, even when you say it modifies the later language rather than the earlier language, you're
Yes, and just briefly on this, Your Honor, in the guardianship of RADA matter before this court in 2021, if language is in one section of a statute and is omitted in the other section of the statute, the court presumes that the purpose was intentional.
Thank you.
May it please the court, counsel. We've talked about the issue with regard to negligent retention a fair amount. Yeah, for sure. And
I understand the position of why you would file a motion to dismiss when you don't have, when the plaintiff didn't have a certificate of merit in this particular case. Looking at the big picture, though, it seems a little bit difficult to, if you're insisting that a negligent retention or hiring claim needs an expert under the certificate of merit standard, that means you also have, that person has to meet the qualifications under 147, 139, which then significantly limits the type of people or that could actually work as an expert or serve as an expert in that capacity, as opposed to kind of the second argument, which isn't, I don't think, an issue actually in the Pratt case because the motion to dismiss was granted, but separate from more of a 668.11 type issue of maybe we don't need a certificate of merit, but because of the intricacies of the decision making related to a doctor, you still need an expert. And if you don't have an expert eventually, then with respect to the retention, then it shouldn't go to the jury. Why are you trying so hard to fit it into that certificate of merit framework and then limit the availability of experts?
so I'm not going to come up with a good example off the top of my head, but I'm certain that there are very specific fields of medicine, specifically for patient care, let's talk about, where the field of experts is small. Brain surgery of some sort may require, there may not be that many people who are able to do that. The real question here isn't that you can't ever find an expert. The pool of candidates might be limited, but you can find one. And of course, as I read 147, 140, if an expert ultimately is required pursuant to 668.11, that means it's required to establish a prima facie case, which means 147, 140 required an expert on the front side.
668.11, the prima facie case in 668.11 is broader than 147, 140, which is very limited to the types of negligence. I don't have the language right in front of me now. It's limited to, I don't have it, that negligence in the practice of that profession. So that's different than just, it's not just every prima facie case. It's only when that prima facie case includes an element of negligence in the practice of that profession.
It's profession, occupation, or patient care. And I
mean, that clearly, right.
I understand, we're not talking about that. Retaining a physician to determine if a physician is fit or unfit for the position requires an expert witness to evaluate all of those things. And that is the occupation of Tri-State. It is the profession of Tri-State. I misspoke earlier regarding Judge Heinemann's decision. I went back and looked at it in between. He evaluated it as the occupation of Tri-State includes retention. The occupation of a medical provider, which Tri-State is, means they fit perfectly into the statute.
Back to Justice McDonald's question, which is, I think that you said you don't actually have to be licensed to perform that role, which means that 139 requires an expert with a license when the people actually doing the hiring don't need a license. I mean, isn't that odd?
It's odd. I suppose it is odd on its face. But the fact that the potential for individuals doing the hiring without the guidance of a peer review committee that is made up of physicians, that goes through the process of evaluating these types of whether it's malpractice or it's concerns regarding Medicare billing fraud, somebody's got to evaluate those from a medical perspective and provide that guidance to some CEO who actually is the one who signs the employment contract. I'm happy to answer any and all questions on the negligent retention. Otherwise, I'll go on to the other. Of course.
We were just beating a dead horse at this point, but we have time. So the question is, subsection 1 of 139 says the person has to be licensed in the same or substantially similar field as the defendant. So the defendant in this case is the corporate entity that doesn't hold a license. And maybe just how do you kind of solve that problem of requiring an expert that has the same license as the defendant who's an entity with no license?
The evaluation is that you have to have somebody who serves in that role. And I appreciate that Tri-State in and of itself doesn't have a medical license per se, but its individual providers do. And you need someone who can evaluate that from the start on
with your other argument with Dr. Marfucci. That's right. Like on the one hand, you want a very hyper-technical reading of the statute when we can kick claims out of court. But, you know, on the other hand, maybe we should just be a little more generous, kind of reach a practical result. We know corporate entities don't have a license, but we should overlook that. It seems like we should do it one way or the other, right? Like we should interpret this in a practical way that's fair to both parties and consistent with the intent of the legislature or not, right?
I agree with you. I really do. And forgive me if it appears I'm making a technical argument on 147, 139. License to practice has real meaning under the legislation and regulations governing licensure.
I mean, if you're going to require that their expert be licensed to practice, and now we're talking about a lawsuit against a corporate entity for hiring, which is not activity that's in any way licensed. It sounds like in one area you want to take the language of the statute and ride that language, and in the other area you kind of want to work around the language of the statute a little bit. Am I missing something?
Not necessarily. I mean, the entity is providing a, like I said, and accept it or reject it as you wish. The entity retains physicians to provide medical care, and the analysis requires medical judgment. Now, does that ultimately make it not a 147, 140 question, but rather a 668-11 question? I suppose I could understand how you could get to that analysis. That the reality is there's no 668-11 opinion either that Tri-State in any of its cases violated the standard of care or shouldn't have retained Dr. Smith. But as it relates to
We've got a statute that's arguably ambiguous as to the inactive license issue, and we have a case of first impression. If we hold that that license needs to be active, should we allow on remand for them to get a new expert or for their expert to get his license activated?
As it relates to it being an issue of first impression, I guess I respectfully disagree with an analysis that says 147, 139 is ambiguous, again, because the words say what they say, and those have real meaning when you dig into what does a license to practice mean? There's practice and there's not practice. When you're licensed to practice, you have to go to CLE, or CME, I should say. License that is inactive does not. It creates a different expectation. And the use of the word active versus not using the word active in paragraph 2, these work together. One is a past in the past, one is a present situation. Are you presently licensed to practice? And as I said, I don't believe it's ambiguous, because when you say, oh, what does it mean to be licensed to practice? The legislature and the regulations specifically tell us what it means to be licensed to practice. We know what that means. And then the actively practicing part in the second section shouldn't necessarily be read into the first section, because the second section relates to, are you actively practicing in the area? An example, if I could, an internal medicine physician is licensed to practice and is qualified under his license to work in the emergency department. 10 years go by, so he's qualified under number 1. 10 years go by before he has ever seen a patient or done anything, or since he's ever seen a patient or done anything in the emergency department. He then gets hired to offer opinions about care provided in an emergency department setting. He's qualified under number 1 because he's licensed to practice in the same or substantially similar field, but he has not actively practiced in the area that's at issue, because he hasn't practiced in the emergency department for more than 5 years. That
Of sub 2, that you can either be actively practicing or a qualified instructor. So you have a qualified instructor at a med school who's instructing for years and years and years and is still doing that, but has a license, but it's not an active to practice license. First of all, I'm not sure how common or uncommon that is, but it seems like it would be fairly common. And maybe we're outside of the record here, but I would like to know, kind of what your general understanding of that is. And does that mean then, I think if you do have someone in that situation, that means that they would not qualify as an expert, correct?
agree with you that they would not qualify as an expert if they do not have a license to practice as defined by the Iowa Code and regulations. As it relates to professors in medical schools having an active license or not, you'd knock me over with a feather if professors in the medical school don't have active medical licenses at the University of Iowa, for example. I'd be surprised.
It's a teaching hospital but what about Des Moines University here? I don't think that they're associated with a hospital, at least like the U is.
Different situation, but again, like I said, we're outside the record, and it's certainly not an analysis I have done. The short answer is I don't think a professor who lacks a license to practice in whatever state they're practicing in would qualify as an expert under that scenario.
They were a practicing doctor. They've retired from the practice and now they're teaching. So they they still have a license, but it's inactive now because they're not going to be practicing. But they're teaching, to your example, they're teaching specifically about ER standards or whatever. And that's what they had practiced in before, and now they're teaching that. So they practice, and now they've been teaching for the last 10 years in that. They have a license, but it's inactive because they're not currently practicing. That person cannot testify or serve as an expert.
That's our analysis, and we think that's what the statute in the context of the rest of the Iowa Code and the regulations contemplates.
Was the legislature trying to solve by requiring, in your view, an active license?
I'm not sure what problem existed before. The intention of it, from my perspective, is we want somebody who is actively practicing, ergo attending continuing medical education, and what goes up, theoretically anyway, goes along with an active medical practice, as opposed to at the risk of throwing him under the bus, my now retired partner Marv Heidman has been retired for decades, but keeps a license. He's not active. He's at a certain age. He doesn't attend CLE anymore, but keeps his license. It's trying to make sure that the person is both actively practicing and and then part two.
Part two, practicing within the 5-year period. So that way we know the person is at least familiar with reasonably recent standards of care. right?
Yes, but we can't ignore that part one exists. Part one exists,
Problem you were talking about, which is we have people who are actively practicing.
part two addresses, back to my example, it can sort of work in reverse. My example of the internal medicine doctor could have been doing ER work within the last 5 years, but he's not actively practicing. Dr. Marfuji here fits the same result. If we're to take the legislature by what it says and what it means based upon the rest of Iowa code, then we find ourselves in a spot that says, for reasons we in this room can't necessarily state with certainty without getting into the heads of the legislature, they wanted an active licensed physician and somebody who had practiced in the particular area at issue within the last 5 years.
Dr. Marfuji, that issue. Can an expert who's not actively licensed, who becomes actively licensed at some point after signing the certificate of merit, can that be applied retroactively to cure a defect? So could that be a substantial compliance cured by him becoming active at some point, at least before trial, right? Because it says he has to be, if you're right, he has to be actively licensed to testify. So can that work retroactively?
The court can do what it wishes with the comment, one comment that is, up to now, there hasn't been an appellate decision where a substantive failure to comply is treated as substantial compliance. And we would say this is a substantive failure to comply under the statute.
Counsel, could you address my question about the second order in the Pratt case? It seems like that we'd already granted interlocutory review in the first, as to the first matter, and so it's categorically improper for the district court to have entered another order. Do you have an opinion?
I don't know that the matter had been fully stayed to issue that order. I will say that that may be a factor for the court to consider unique to the Pratt case. The court, of course, is taking under advisement the same issue in 3 or 4 other cases where that's not an issue. And so to the extent necessary, if there's something wonky procedurally here, the court can address the substance of the issue through the other cases where it's in front of you properly. If there are no further questions, I'll conclude my remarks. Thank you.
Thank you, Your Honor. I'd like to bring up a potential reason there might be a differentiation as far as an expert being on an inactive license and having actively practiced in the 5 years prior to the incident as to why that logical consistency would make sense. In Iowa, we have a tolling statute for minors. If you're a young child who's injured in a medical malpractice case, they could have until they're 18 to bring a lawsuit. So you could be talking about a lawsuit a decade in the future about something happening today. So under the statute, the testifying expert would have to have actively practiced in the 5 years prior to the negligent act. And so, you know, you could have people who were actively practicing, say today, and you bring a case in 2030 or 2033, that person would still have to be actively practicing under Mr. Wright's interpretation and have actively practiced in the 5 years leading up to that. So I think that's a potential logical consistency.
That sounds like you could have the potential for a harsh result. On the other hand, you have explored that you have pointed out that under Mr. Wright's reading, the 2 requirements are not redundant. I mean, you have to have an active license according to Mr. Wright under the first subsection, at the time you're doing the certificate, and you have to have been actively licensing, actively practicing at the earlier time period and before when the alleged malpractice occurred. So it's not a redundancy, is it?
No, Your Honor, I think that that's exactly the situation that might be contemplated. You could have someone who was actively practicing, say a pediatrician in this field, and then they went on to retire.
Aspect. I mean, one rule we have is we normally say when sort of the same phrase is used kind of in the vicinity or in the same statute or in the same general area. So elsewhere in 147, states, and this is referring to the medical board here, it says the board shall, upon presentation of a license to practice a profession issued by the duly constituted authority of another state with which this state has established reciprocal relations, license the applicant to practice in this state. So if we're going to read license to practice consistent, doesn't that mean that Iowa has a statutory obligation to, and I think it's in New York, you're licensed for life, right? Is that correct? I think that's what it was with Mr. Marfuji. So you could have someone who's, been retired for 30 years, and they could come into Iowa and under this statute immediately be licensed to practice if we're reading that correctly. Am I right? Or do we have to read the language different in the same words differently in a different statute?
I think that one of the canons of construction is that you look at the statute in question, but you also look at the entire picture. So those are all factors that can go into this analysis.
In the earlier case this morning, we talked about or there was a pitch made that on this question of first impression, if we rule against the plaintiff, that we should allow leave to cure on remand. What's your pitch for that? If we hypothetically hold that an active medical license to practice is required, should we put in our opinion that Dr. Marfuji can cure that, or is it too late?
Outside the record in this case, but Dr. Marfuji actually is now back on active status. So we would say that he would be qualified to testify at trial, but that's not on the record in this case. I don't have anything further unless there are additional questions. Thank you, Your Honors. It's been a real honor to be here. Thank you.
Of Pratt, both Pratt cases versus Smith, 220403 and 221573 are hereby submitted, and court is adjourned for the morning.